Will the testimony you give in this hearing be the truth, the whole truth, and nothing but the truth? So help you God.
It will.
Have a seat. Would you like to introduce your family? You've got a lot of children there, and they may want to...
I would, Senator. They've taken a lot of trouble to get dressed up and come downtown. I think the little ones would probably want to leave after the first recess, but I did want to give them their moment in the limelight here, if I can remember all the names.
We'd like for those present to see them all. You have 9 children. I believe you have 8 of them here, don't you?
I think all 9 are here, Senator. I think we have a full committee. My wife, Maureen, is at the right in the front row. Next to her is Meg. Her real name is Margaret, but she said I should introduce her as Meg because when she's called Margaret, she's usually in trouble. Catherine, Christopher, Matthew, and in the next row from the other end, Mary, Anne, my oldest, Eugene, John, Paul, and that's it.
You have a good memory.
But don't try me on the ages, Senator. I'd also like to introduce, Senator, behind me, my law clerk, Patrick Schultz, who's helped me in getting together the materials I'll probably need for this hearing.
Judge, do you care to say anything before we begin questioning? Do you have an opening statement you'd like to make?
No, I don't, Senator, except to express my honor at being nominated by the President and the fact that I'm happy to be here and look forward to answering the committee's questions.
Now, I believe Senator Biden suggested we have 20 minutes for the opening round until we get around. Then if we have a second round, it'd be 10 minutes from then on. Same way we did in the relinquished hearing. Senator Grassley, did you ever make an opening statement? Yes, sir. Thank you. Judge Scalia, there are some very obvious differences in the roles of a Circuit Court of Appeals judge and an Associate Justice of the Supreme Court. The most glaring difference, I suppose, is that the Supreme Court has the final word on what the law is. It is the final ruling in the appeals ladder and can be overruled on constitutional interpretations only by a later Supreme Court decision or by constitutional amendment. What do you view as other major differences in the role of a Circuit Court judge and an Associate Justice?
Well, I think you've correctly identified the major one, that there's no one to correct your mistakes when you're up there, except the constitutional amendment process. In a way, there's a lesser body of law to look to. As a circuit judge, I accept as precedent not just the opinions of the Supreme Court, of course, but the earlier opinions of my own circuit, and accept as very persuasive the opinions of other circuits. So it's a much more vast body of law that I have to consult in order to make my decisions. At the Supreme Court level, the most persuasive precedent is just Supreme Court precedent, although to some extent lower court opinions are looked to, but it's not nearly as important. I think you put your finger on what the main difference is, and that is that at the circuit court level, the opinions of the Supreme Court are the last word, and we follow them unwaveringly. At the Supreme Court, that is not quite the situation. The Supreme Court is bound to its earlier decisions by the doctrine of stare decisis, in which I strongly believe. Other than that, I suppose it's more difficult to be sitting in a panel of 9 judges all the time. On my circuit court, we now have 11, and when we sit in bank, it's a much more ponderous group to bring to a consensus than is a panel of 3, which is the normal panel. I expect that would be quite a difference.
Judge Scalia, As we rapidly approach the 200th anniversary of the Constitution of the United States, many Americans have begun to express their views about the reasons for the amazing endurance of that great document. Would you please share with the committee any views you may have regarding the success of the Constitution and its accomplishment of being the oldest existing Constitution in the world today?
I'd be happy to. I think a lot of Americans don't realize what a
And I don't have to go into the whole history of it. Just
I won't do it. I won't do it. I think most of the questions today will probably be about that provision of the Constitution that's called the Bill of Rights, which is a very important part of it, of course. But if you had to put your finger on what's made our Constitution so enduring, I think it's the original document before the amendments were added, because the amendments by themselves don't do anything. The Russian Constitution probably has better, or at least as good, guarantees of personal freedom as our document does. What makes it work, what assures that those words are just not hollow promises, is the structure of government that the original Constitution established, the checks and balances among the three branches in particular, so that no one of them is able to run roughshod over the liberties of the people as those liberties are described in the Bill of Rights. If I had to put my finger on what it was that's made the difference, that's it.
Judge Scalia, under the Constitution, certain functions are reserved to the federal government and others to the states, or rather they've been delegated to the federal government and others reserved to the states. Would you describe in a general way your view of the proper relationship between federal and state law?
The proper relationship, of course, is that federal law is supreme. If the federal government acts in a field over which it has authority, state law has to step back. When that should happen, of course, is most often a question of prudence, and that means that it's most often a question for this body to decide when it wishes to displace state law and when not. When it does so, that's the end of the matter.
Judge Scalia, since the announcement of your nomination to be an Associate Justice of the Supreme Court, you have been criticized by some for decisions you have rendered regarding the First Amendment and libel. Would you please give the committee your view as to why your interpretation of the First Amendment with regard to libel led to this criticism?
Well, I have to say it must have been misunderstanding, Senator. I don't know of anything in my opinions or my writings that would display anything other than a high regard and desire to implement to the utmost the requirements of the First Amendment. As a matter of fact, Senator Moynihan mentioned this morning I'm the first academic to be nominated to the court since Frankfurter. I've spent my life in the field that the First Amendment is most designed to protect. In addition to having been a scholar and a writer as a scholar, I think I'm one of the few Supreme Court nominees that's been the editor of a magazine. Why anyone would think that if anything, if I were to have a skewed view of the First Amendment, Senator, it would be in just the opposite direction.
Judge Scalia, the Supreme Court's decision in Marbury versus Madison is viewed as the basis of the Supreme Court's authority to interpret the Constitution and issue decisions which are binding on both the executive and legislative branches. Do you agree that Marbury requires the President and the Congress to always adhere to the Court's interpretation of the Constitution?
Well, Marbury is, of course, one of the great pillars of American law. It's the beginning of the Supreme Court as the interpreter of the Constitution. I hesitate to answer, and indeed think I shouldn't answer, the precise question you ask. Do I agree that Marbury versus Madison means that in no instance can the either of the other branches call into question the action of the Supreme Court. As I say, Marbury versus Madison is one of the pillars of the Constitution. To the extent that you think a nominee would be so foolish or so extreme as to kick over one of the pillars of the Constitution, I suppose you shouldn't confirm him. But I don't think I should answer questions regarding any specific Supreme Court opinion, even one as fundamental as Marbury versus Madison. If you could conclude from anything I've written or anything I've said that I would ignore Marbury versus Madison, I ought to be in trouble without your asking me specifically my views of Marbury versus Madison.
Yeah. Judge Scalia, 20 years have passed since the Miranda versus Arizona decision, which defined the parameters of police conduct for interrogating suspects in custody. Since this decision, the Supreme Court has limited the scope of Miranda violations in some cases. Do you feel that the efforts and comments of top law enforcement officers throughout the country have had any effect on the Court's views? And what is your general view concerning the warnings this decision requires? Now, I want to make this statement. Any question is asked about decisions of the court, if you prefer not to answer them, if you say so.
No, I don't think, I didn't take that
anything that may
question
come before the court, I don't want you to feel obligated to answer.
As to the second part, Senator, what do I think of those warnings? I'm happy to answer it as a policy matter, assuming the question is not, what do I think as to the extent to which those warnings in one circumstance or another are required by the Constitution. As a policy matter, I think, as far as I know, everybody thinks it's a good idea to warn a suspect of his rights as soon as is practicable. I don't know anyone that thinks it should be otherwise. As soon as the suspect is brought within the control of the police, he should have knowledge of what his rights are as a policy matter. The other part of your question, if I recall, was do I think the Supreme Court has been influenced by the views of police officers and law enforcement officials? I suppose. I don't think the Supreme Court lives in a vacuum. It reads the newspapers. I suppose it's influenced by the reaction of the society to its decisions. At least I hope it is. I think it should be. One would not know whether one's decisions are doing good or bad unless one consulted the effect of them.
Judge Scalia, in 1972, the Supreme Court in Thurmond versus Georgia struck down the death penalty provisions in federal and state law on the basis that under the statutes the death penalty could be imposed in an arbitrary and capricious manner. In 1976, the Supreme Court, in a series of cases beginning with Gregg versus Georgia, held that the death penalty was constitutional when imposed under certain procedures and criteria. In the years subsequent to these decisions, the Supreme Court has reviewed many challenges to death penalty statutes. Do you feel the Supreme Court has now provided sufficient guidance in this area?
Whether it's provided sufficient guidance, I'm not sure I have the data that I'd need in order to answer that question. It's always a difficult problem. One of the hardest problems, I think, for an appellate judge is how broadly one wants to write an opinion. Certainly providing guidance is one of the purposes of an appellate opinion. So you can write an opinion very broadly, which will answer all the questions for the next 50 years, or you could write it very narrowly and just answer this particular case and let the next one come up when it does. It's a hard call as to how far you go in one direction or another. I really don't know whether the Supreme Court has been as informative as it could be or should be. I think it's, I have to say, not having been there, I'm sure they did what they thought was the best.
Judge Scalia, there are approximately 1,300 inmates under death sentences across this country. Many have been on death row now for several years as a result of the endless appeals process. Would you favor some limitation on the extensive number of post-trial appeals that allow inmates under death sentences to avoid execution for years after commission of their crimes?
Well, Senator, nobody likes frivolous appeals, I suppose, in any matter, criminal or civil. But to the extent that your question is asking about legislation, I shouldn't have a view about it. And to the extent it's asking about whether the Supreme Court ought to change its view of what the law requires to provide fewer appeals, I ultimately will have to have an opinion about it, but shouldn't set it forth here.
Judge Scalia, in the last several decades, we have seen a steady increase in the number of regulatory agencies which decide a variety of administrative cases. I realize that the scope of judicial review of these administrative cases vary from statute to statute. However, as a general rule, do you believe that there is adequate opportunity today for the appeal of administrative decisions to the federal courts, and do you believe that the standard of review for such appeals is appropriate? Again, I remind you, anything you feel that you should not answer, any matter you may feel will come before the court.
No, I don't think that will. I mean, appropriate, I assume you're saying appropriate. You know, Congress can alter the standard of review considerably. I'm not aware of any great dissatisfaction in the administrative law community, and I think I'm fairly familiar with that community, having been a denizen of it for a number of years. I don't know that there's any great dissatisfaction with the general scope of review of administrative action that now exists, which is essentially an arbitrary or capricious standard. The fine call is for the agency, and the courts look it over to see that it hasn't been so unreasonable as to be arbitrary or capricious. As far as I know, it seems to have worked pretty well. As to whether all review, whether there is review in enough instances and there should be review in more cases or in fewer cases, that's really a call for the Congress, on which I don't have any particular special views.
Judge Scalia, concern has been expressed with respect to the bureaucracy of the federal courts, the increase in clerks and support staff, and the supposed insulation of judges from personal decision-making. At the same time, the workload, the increase in complicated cases which raise technical scientific issues and other highly specialized disciplinary matters, suggests that judges and justices need more and more specialized assistance. Do you think that in addition to law clerks, the Supreme Court needs to appoint clerks or assistants with particular scientific or professional expertise, or is the solution to take certain issues involving science and other abstruse areas out of the courts altogether? Or is there some other solution?
No, I think you have them there, Senator. I personally, and I guess this is, you might get as, no, I don't think you'd get as many answers as you asked judges. Personally, I would not want a scientific expert on my staff. Institutions tend to do what you give them the capability to do. And if you give courts scientifically expert staff, they are going to become bodies that inquire into the scientific rights and wrongs of particular decisions. And simply the way our system is set up, those scientific judgments have been left to the Congress to make when it passes legislation, and to the executive to make, and to an even greater degree, by delegation from the Congress. As I said earlier, with reference to your question on the standard of review, all the courts are there for is to see whether the agency has followed the proper procedures, which is critically important, and whether in the final judgment that the agency reaches, the agency has been within the bounds of reason. I think I can tell without a scientific expert, just on the basis of the record in the case, whether it's within the bounds of reason. And I personally would not want the courts to go any further than that, or you're just duplicating the work of administrative agencies.
Judge Scalia, do you believe that the court has given sufficient consideration to relevant economic analysis in evaluating the effects of restraints of trade? And are you satisfied with the guidance that the court has provided on the proper role of economic analysis in antitrust law?
Senator, antitrust law has never been one of my fields. Indeed, in law school, I never understood it. I later found out in reading the writings of those who now do understand it that I shouldn't have understood it because it didn't make any sense then. As to whether the court has, so I really am in no position. All I can tell you is hearsay, Senator. From those who follow the field, I do understand that the rules have changed in recent years and that the court is applying the principles and the data that economists have accumulated over the years regarding the sensible application of the antitrust laws. But I haven't had a single antitrust case since I've been on the D.C. Circuit, and I haven't complained about that either.
Judge Scalia, Chief Justice Berger, and others have complained about the poor quality of advocacy before the nation's courts, including advocacy before the Supreme Court. Do you feel that legal representation is poor? And if so, what, in your opinion, should be done to improve the quality of this representation?
Senator, I can only speak for my own court, and before my court, it's excellent. I can't speak highly enough about the bar that practices before me. I think an enormous proportion of highly competent lawyers who do fine work not only for their client but for the court in informing us of the issues of law that we have to decide. On the basis of what I see before my court, which is maybe not a typical court, the advocacy is good.